Provisions regarding anticipatory bail have been in much discussion. Can a court direct an accused to surrender while rejecting anticipatory bail?
Whether a person should go for anticipatory bail or not is a very difficult call which a lawyer has to take when he meets a client who is being subjected to a criminal case. It has been my experience as a lawyer that many a times we ask a client who is accused of an offense, who is otherwise not being arrested, to file an anticipatory bail, and if that anticipatory bail gets rejected, invariably the police think that they are duty bound to arrest him, notwithstanding the fact that he was not otherwise required for interrogation by the police. So when a person accused of a crime comes to any lawyer and he says that this is the criminal case filed against me, now what are the options for that lawyer? He can say, this case doesn't look like you being arrested, you were available all this while, and if the police has not arrested you, they will not arrest you in future also. And accordingly, don't go for anticipatory bail. This should be the normal advice for any lawyer. But the lawyers also have to be cautious many a times, and they don't want a situation to happen where they advise their client not to go for anticipatory bail, and in a couple of days, the police actually come to arrest him. And then that advice really goes against the client. But the flip side is more dangerous, because when the anticipatory bail petition is filed, and if it's a serious offense or even if it's not a serious offense, by the adversarial nature of litigation system that we have, the prosecution starts vehemently opposing the grant of anticipatory bail, saying that I require a custodial interrogation, etc. Now, if the anticipatory bail had not been filed, they would not have an occasion to say all this. So they argue all this, and once they argue all this, the court, if it grants anticipatory bail, the client is well protected. But if the client is not granted anticipatory bail, there is a likelihood of the client getting arrested, because the prosecution feels that it has got a victory in opposing the anticipatory bail. And because the victory signifies their right to arrest, they invariably arrest that person, and for no reason, because they had not arrested him in the first place when the case had been registered. But a more disturbing trend has been seen by some courts, which, while rejecting anticipatory bail, also direct the police to arrest the accused. Now, that is something which, according to me, is completely impermissible in law. Whether a case for anticipatory bail is made out or not is the only remit for the judge deciding an anticipatory bail application. He may say that a case for anticipatory bail is not made out, but his further directing that the person should be arrested because the anticipatory bail is rejected is, according to me, completely not justified or not legal. In my view, the status of an accused should not change merely because he decided to file for an anticipatory bail. And if he was not being arrested in the first place prior to his not filing the anticipatory bail, he should not be arrested merely because his anticipatory bail is rejected. And this will actually be very salutary, because many a times we find people get arrested because anticipatory bail has been rejected, and they languish in jail for long periods of time as an under trial, clogging the system and clogging the prisons. So this power of arrest is a very important power with the police, and they have to exercise it with great caution. And in every criminal case, if they start arresting the accused, it will be impossible for our present capacity of our jails to accommodate all the under trials in the country. So it's completely not fair to arrest somebody simply because his anticipatory bail has been rejected, and the status of the accused should remain the same, unless, of course, there was a need to arrest him in the first place, or he was absconding till the time he filed this anticipatory bail application, or some new fact is discovered after the rejection of the anticipatory bail, which was not known to the police prior to his applying for the anticipatory bail, because of which they had not arrested him earlier. And after the rejection of the anticipatory bail, this new fact gives them a reason to take him into custody, either for the purpose of interrogation, or for the purposes of ensuring that he doesn't flee from justice, and to send him to judicial custody. Only in such kind of situations the arrest of an accused should happen. Otherwise, merely rejection of anticipatory bail should not in any manner alter the status of an accused in a trial.